when I was in Portugal, and I taught there for a week, and he was gracious enough to um, meet with me. And not only is he an amazing law professor, but he then is now a justice on the Constitutional Court in Portugal. And I am just honored for him to be here. And he's going to kind of give us a little bit of the basics, and is what he's welcome to take questions as well, and when the time is right. So thank you very much for being here.
Okay, thank you, Melanie. Thank you so much. It's wonderful to be here with you today. Just a few, but in any case, um, as Professor Melanie Reid was saying, I'm an associate professor at the Faculty of Law of the University of Lisbon, where I teach several courses of public law. Right now, because of the courts, I can only teach a PhD seminar in public international law. So that's the only thing I have with the university currently, because quite frankly, it's impossible to do more than this. And for a year, I am a justice at the Constitutional Court of Portugal. So this is one difference to begin with regarding your Supreme Court. We don't have a term for life. So our term is 9 years. So I began last year, so I still have 8 years, more or less, to complete my term. The court has 13 judges. So 13 judges, 10 of which are elected by parliament, and the other 3 are elected by the first 10. So it's a system of co-optation. This means that let's say the political influence is greater regarding the first 10 than the last 3, because the first 10 are actually elected by political parties, and according to our constitution, this election requires a 2/3 majority. Considering our political party system, this means, because we have 2, well, now things are a little bit different, but we still have 2 big political parties with 2/3 of parliament, and this means that traditionally those 2 dominant parties are able to, between the 2 of them, actually elect the justices of the Constitutional Court. Okay. The remaining 3, as I was saying, are chosen by a co-optation system. So the first 10 choose the remaining 3. This was my case. So I was chosen by my, well, now my peers. So I was not directly elected by parliament, but chosen by the other justices. It's an interesting system because it introduces some balancing on what sometimes is called a political influence on the Constitutional Court, which at the end does not exist, because if you take the decisions that we have, namely the most important ones, and I will come to that later, it is not possible to see a tendency between right and left or something like that determining the orientation of the voting. So this is actually a traditional way to keep the Constitutional Court in a large political balance, which allows for the main political parties to not feel, let's say, the political process threatened as a whole by a constitutional court that at the end is a negative legislator, as Kelsen would say or said, because we can actually cancel what the legislative power does. But the system works quite well. The system works quite well, and it's about that. So the term is 9 years, and it's not renewable, which is an important issue. Of course, if the term is for life, the things are different. But if it is not, but there is the possibility of re-election or re-nomination, that can raise issues regarding independence and even impartiality of justices. We had that in the past, but the Constitution was amended to, let's say, bring some perfection to that issue. So a 9-year term, but for you to understand what the Portuguese Constitutional Court is, before telling you about what we do, sorry, I have to place the court for you in our judicial system. Otherwise, things can get a bit blurred, and the jurisdiction that we actually have might not be actually understood. We have, so we are not a federation, so we have no distinction of courts of law regarding with that criterion. But we have two different orders of courts, all courts of law, but in the European tradition, we have a group of civil courts or general courts, which cover civil law issues and criminal law issues and labor law, and well, to say private law would be too much, but the counterpoint is that we have another order of courts, which are administrative and tax courts, and those courts only trial issues of administrative law and tax law. Of course, this would get us very far to explain why the system is like this. But in any case, this is more a specialization of courts of law than anything else. The thing is that at the top of these two different orders, we have two different Supreme Courts. So the Supreme Court of Justice for the first, and the Supreme Court of Administrative and Tax Law courts for the second. These Supreme Courts are at the top of the hierarchy of these two different orders. And the Constitutional Court is on top of all of this. So we are the tip of the pyramid or tip of the spear, depending on the perspective that you prefer. This means that we do not trial cases as such. So we only look at the constitutionality of legal rules. We don't look at the constitutionality of these courts or those courts' decisions. So if a decision of the Supreme Court of Justice violates by itself the Constitution, that is not for us to look at. We will only look at those decisions if, by any reason, and I will get into some details a bit further, if the legal rules that were applied by the Supreme Court or other courts were by themselves unconstitutional. And this can happen in many ways. So we don't trial cases in the way that for instance, the Supreme Court in the United States does. We only look at legal rules. So if someone is, let's say, unconstitutionally deprived of his or her freedom, that's not for us to decide. That's not for us to control. But we can control the constitutionality of, let's say, a certain rule of the criminal code that was applied in a certain case. So if that particular rule regarding, let's say, tax fraud or homicide or whatever, if that particular rule is considered unconstitutional by the parties in a certain case, they can bring that issue to us. And if we rule that the rule, sorry, is unconstitutional, then the courts must rule again, taking into account the Constitutional Court's decision. But this is only a small fraction of what we do. Let me get back to tell you this. Here in Portugal, the Constitutional Court has a complex jurisdiction. We do not look at the constitutionality of legal rules only in the context of cases. We also have a general or abstract jurisdiction regarding legal rules. What does this mean? This means, for instance, that we have a preemptive jurisdiction regarding unconstitutional rules. If the President of the Republic receives from Parliament a bill that he has to sign, before doing that, he can call the jurisdiction of the Constitutional Court. We have a very small number of days to do that analysis, 25 days tops, which is a very, very, very short period to do this. But this can happen if the president has doubts regarding the constitutionality of a certain bill that he must sign, and is almost sure or is convinced that the bill is unconstitutional because the majority was not met, because it violates principles of proportionality, equality, whatever. And if we rule that that bill is unconstitutional, then the president cannot sign and must return the bill to Parliament. There are other countries in the world that have this system, but not the majority, of course. And then it's possible to have a successive control. So, taking the same example, the president might sign a certain bill, but after the bill is in force, sometimes years after the bill is in force, sometimes presidents after the one that originally signed the law, it's possible to call the jurisdiction of the Constitutional Court to see if that legal rule is according with the Constitution or not. Not only the president is able to do this, but also our Attorney General can do this, and our Attorney General has nothing to do with your Attorney General in the United States, because our Attorney General is not part of the executive, nor has any kind of relationship with the executive. It's a totally independent body. And members of parliament can also do that. A tenth of our members of parliament can call the jurisdiction of the Constitutional Court regarding a certain law, years sometimes after it is in force. So this means 23 members of parliament, because we have 230 members of parliament. These forms of control have no relationship with particular cases, as you can see. When I was telling you about the other courts that we have in Portugal a few minutes ago, I was thinking about a third possibility of control that the Constitutional Court has, which is, of course, or comes in the sequence of a certain case that is being tried by the courts. And there are, of course, many differences between the two forms of control that I was just mentioning and this third one that was, well, in a way, the beginning of my of these few words that I'm sharing with you today. Regarding the general or abstract control, the two forms of control that I mentioned before, if, namely the second, if the court decides that a certain rule is unconstitutional, either the president cannot sign, or if the law is already in force, what happens is that it is declared void by the Constitutional Court. And this means that the legal rule in itself, or it doesn't even appear in the legal order in the first place, or else it is annulled in a way. So this means that it disappears from the legal order and it cannot be applied in any case or in any way. And the effects are retroactive. So if the law was approved 10 years ago, this means that we will destroy everything that happened in the last 10 years according to that legal rule, unless the Constitutional Court decides that because of reasons of equality or others that our Constitution allows or calls for, we may limit the effects of our declaration of unconstitutionality. And sometimes this happens. Sometimes this happens. Of course, there are particularities regarding criminal law, but that's too specific for me to open that particular dossier right now. Okay. In the control of constitutionality that we do regarding specific cases, what happens is that if we consider that the rule that was being applied in case A is unconstitutional, then the courts will have to decide again without applying that rule, or without applying that rule with that interpretation that the Constitutional Court considers that violates the Constitution. And this decision, this Constitutional Court's decision, only binds that particular court in that particular case. We have no rules of precedence. Of course, this tends to be, let's say, relativized, because for reasons of equality and of the functioning of the judicial system, the courts, of course, tend to look at other courts' decisions, and even the Constitutional Court does that. So if a certain rule was already considered unconstitutional in another case, most probably the same will happen in case B, in case C, in case D, if the rule is the same and the situation, the interpretation situation is the same or very similar. But in this type of control, we do not eliminate the rule from the legal order in itself. What can happen, this sometimes it does happen. I would not say often, but several times this happens. From the moment we have 3 decisions on the same rule, considering that rule unconstitutional on the same grounds, it is possible to open or to transform these situations in a case of general control. What this means is that the court will open a process of general control, normally at the requests of the Attorney General or the Attorney General's office, with the aim of declaring the rule unconstitutional with general effects. And this brings us back, those situations, to the second type of control. And in those cases, yes, we are going to eliminate, finally, that legal rule from the legal order. This is pretty much a very general scope or perspective of what we do. The Portuguese system is inspired both by the Austrian or Kelsenian system and the American system. The Austrian or Kelsenian system means that there is a specific court with a specific jurisdiction to analyze constitutionality, and only that, of laws. And the Constitutional Court is that. But the Constitutional Court is also the end of the line for other cases trialed by other courts, as you can see. Our Constitution forbids all courts of law from applying unconstitutional rules. This actually means that every court has the duty to, first of all, make sure that the rules that it's being called to apply are not unconstitutional. So our system is not only a system of concentration, but it's also a system of decentralization by all courts of law to first look at the constitutionality of the rules that they are being called to apply. And at the end, that issue might rise to the Constitutional Court. Actually, this is this influence, this last influence, is pretty much inspired in the American system. And it's we had several constitutions before the one that is in force today. The Constitution that is in force today is from 1976. But this influence of the American system comes from a previous constitution that we had, the first Republican Constitution of 1911, We had 3 constitutions in the 19th century and 3 constitutions on the 20th century. And this particular influence that we still have today comes from the 1911 one, which actually was very inspired by the American system. Sorry. It's interesting to see how these influences work, and not only in institutional terms, but also in terms of legal culture. In in the decision that I gave a few weeks ago, well, it was not a singular decision, but the case was mine. I was the rapporteur of that case. I actually cited Stephen Breyer on his last book on reading the Constitution. So we are very open to other influences of other institutions abroad, but also legal theory in other countries and other systems, exactly because we have this influx of many from many parts of the world. I said at the beginning that our constitution, our constitutional court is very young. That's true, because our country is older than the United States of America. So we have 1900 years of history as a country, but our current constitution is much younger than the Constitution of the United States. And interestingly, the Constitutional Court was not in the original version of our 1976 Constitution. It was a creation from the first revision of that Constitution in 1982, and it began working in 1983. So it's a very, very young constitutional court, namely in comparison with the Federal Supreme Court of the United States, of course. And this is pretty much what I wanted to share with you in a bird's eye overview in just a few minutes. But of course, I still have a few minutes, so if you like to ask some questions or observations, I will be glad to answer or to comment them. Thank you.